Calling the February 14th meeting of the Municipality of Anchorage Planning and Zoning Commission to order. It looks like we have a quorum, so if the Secretary will please call the roll.
Nancy Pease. Here. Jim Frederick.
Here.
Connie Yoshimura. Here. Arthur Isham.
Here.
Bruce Phelps. Stacy Dean.
Here.
Terry Park.
Here.
Dana Cruz.
Here.
Richard Wilson.
Okay, thank you, Madam Secretary. We've got the minutes for Monday, July 12th, 2010. Take a positive motion for approval. And moved by Ms. Dean, seconded by Mr. Fredericks. Is there any corrections to the minutes? Is there any objections? And the minutes are approved. Ms. Yoshimura, if you would take care of the disclosures, please.
Ms. Pease, do you have anything to disclose this evening?
No.
Mr. Fredericks?
No.
Mr. Parks?
None.
Mr. Isham?
I have none.
Ms. Dean? Ms. Dean, do you have anything to disclose this evening?
No.
Mr. Pruz?
No.
And I have nothing to disclose this evening. Thank you.
Okay, thank you, Madam Vice Chair. We've got two items on the consent agenda this evening. I'll take a positive motion for approval. Mr. Frederick moved, Ms. Dean seconded. Is there either one need to be pulled?
I just did one, yes, sir.
Okay, which one?
On the Beach Lake.
The Beach Lake, okay, that's 2010-029. Okay, we pulled item 1B. Is there any objection to item 1A? And that is approved. Ms. Pease, please speak to 1B.
Yes, I just wanted to enhance a little bit the condition A11, or the finding A11, so that it reflects the findings that I spoke to, which are on page 13 of the minutes, and that is it says, the Commission noted that the emphasis on dog mushing and skiing are very important uses to the community and wish to maintain. I would like to insert the word the community wishes to maintain, so it's clear that that's not just the Commission's finding. And then also I had made a reference that it's appropriate to emphasize these winter uses because this is a snowy and colder area that retains the snow well. And that was, we heard that in testimony, and I spoke to that in the findings.
And should that be included in 11 also?
11, yes.
Okay, and could you please state it once again?
Yes. Condition or findings, the findings, which is item A11, insert the words the community before the word wish to maintain. I guess it would be the community wishes to maintain these activities. And then it is appropriate to emphasize these winter uses because this is a snowy and colder area that retains the snow well. And again, that was those were findings on page 13 of the minutes we just approved.
Okay, is there any other comments on these minutes? Let the record show that Mr. Phelps has arrived. Mr. Phelps, do you have anything to disclose this evening? No. Okay, thank you. Any other comments on these minutes? Ms. Pease, we're going to need a motion for approval.
Yes. I move for approval of resolution number 2010-029 with the changes I just made to A11 as to reflect the minutes.
been seconded by Mr. Parks. Is there any objection? And those minutes stand approved as read, or as corrected. Yeah, resolution. Yeah. Minutes. Okay. We'll now move on to public hearing. Item G1, case 2011-017, an ordinance of the Anchorage Municipal Assembly amending provisions of Anchorage Municipal Code, Chapter 16.80 and Sections 2150.035, governing municipal permits for correctional community residential centers. If we could hear from staff, please.
Thank you, Mr. Chair. This subject of this request is an ordinance amending Title 21 regarding community correctional residential centers. Anchorage Ordinance 2011-1 was introduced on January 11th of this year, set for a public hearing in front of the Anchorage Municipal Assembly on February 15th, 2011. There's actually been an S version, a substitute version introduced since that time. However, that substitute version does not change anything in Title 21, which is under your purview. In essence, what this ordinance is intended to achieve is to clarify some inconsistencies between Title 16 and 21 regarding authorities and titles of habilitative care uses in our code and correctional community residential centers, also known as CCRCs. In Title 16, they're currently called quasi-institutional houses. So we're making those clarifications and changes. The other issue, those are primarily housekeeping, but the primary issue is that the land use regulations for CCRCs currently have a cap set on occupancy for the three existing centers, CCRC centers in the downtown area. And occupancy for such facilities is normally set by corrections in terms of different programmatic requirements, bedroom size, kitchens, etc. And they're also licensed by the health department. Not only CCRCs, but habilitative care facilities. Those inherently may change over time and flux depending on the particular type of program in a facility, or each individual facility may need to change or modify its operations based on correctional requirements over time. This ordinance was introduced to be able to place the appropriate occupancy requirements in the section of the code, the health department section of the code on Title 16, instead of in Title 21. The changes you will see, I've also provided you the information in the packet on the particular facilities, their locations downtown, their current occupancy, et cetera. What it does is remove those caps from Title 21, and what that would allow, in essence, in terms of land use issues, is if those three centers wanted to come in and modify their occupancy, they could, because those are limited right now based on their conditional use approvals. All CCRCs require conditional use approval. So they could come in on a case-by-case basis and make application to you to amend those. However, their maximum capacity and how they run the program inside the building would still be handled through corrections and through DHHS, and they would still need to go through those individual permitting processes. The vast majority of the ordinance deals with Title 16 under the Health Department. Mr. Barrett from the Health Department is here to be able to handle that if necessary, if you have any questions for him. Does everybody have a light to read by?
We just wait to hold there while we get the lights back on. We're getting some sort of an echo here, and we started pushing buttons, and it killed the light.
What's before you today is primarily on pages 28 and 29 of the ordinance. I've provided the information. If you have questions, I can provide you more background detail on how these restrictions came into being in the first place and why these program issues ended up in Title 21 instead of Title 16, if you have any further questions on that. To let you know, the other restrictions related to the 3 downtown facilities, they have not changed. This ordinance does not allow them to apply to you to expand their footprint. They're already on limited sites to begin with. If they wanted to acquire any other facilities, again, still a new conditional use. Parking is based on staffing ratios. It is not based on occupancy or number of beds. So characteristics of use that would normally also, that are Title 21 issues, are not being affected by this ordinance. At that time, I will conclude my presentation and be available to answer any questions. Thank you.
Any questions for staff? Mr. Frederick?
Through the chair, Ms. Chambers, in the section 5 that relates to 21.50.035, the standards, section E, the parking requirements, says a center shall provide 1 off-street parking space per each full-time staff member based on the maximum anticipated staffing.
On the floor, maybe?
Correct.
Does it seem a strict interpretation of that would be that if you need, say, 6 people on a shift, that might imply that you have as many as 20 staffers or so that on one shift or another might be employed at the facility, but they wouldn't all be there at one time. Does it make sense to have the parking based on the total number of staff or the maximum number of staff that would be at the facility at one point in time?
Through the chair, Mr. Frederick, I may not have been clear, as clear as I should have been. It currently says and will remain to say a center shall provide 1 off-street parking space per each full-time staff member based on the maximum anticipated staffing, and that has been interpreted to mean maximum anticipated staffing at one time. Part of an issue with parking, this has never been an issue, but, the individuals at the facilities do not drive. There are visitors that come.
Right.
Visiting times and things like that are highly regulated. There may be people in the audience that can testify on that. I've been working with these from a land use perspective for years. It's never been a problem.
Okay,
But it's maximum staffing shift.
Okay, I just want to make sure we didn't have an
No.
issue.
Ms. Pease?
Through the chair, Ms. Chambers, could you explain the table on page 4? I'm not sure which of those numbers are approved occupancies and which are the new maximums.
Certainly. Through the chair, Ms. Pease, page 4, the non-asterisk numbers for those 3 facilities, that is the approved number of beds. Single beds, obviously. Some of them are different in shape, but those are the number of occupants, clients, if you will. They could be in a facility at one time. That's their latest approved by the commission. The commission would still, this ordinance, were it passed, would not say that the commission could not change that in the future if somebody were to comply. For example, if Parkview wanted to come in and change it from 80 beds to, just throwing a number out there, 110, if you decided 110 would be fine, but you wouldn't want them to have more than 115 for whatever reason came before you could still do that. However, at the same time, they would be providing the information from corrections and DHHS on that. But those are their existing approved occupancy allowances. And since 1995, with the last ordinance that regulated these downtown facilities, that ordinance stated that they could not even get a variance to change these occupancy limits. That's why this is before you.
If I may, the asterisk then refers to some temporary higher number that they can currently bump up to?
Well, they were allowed. Glenwood Center did get some interim minor amendments from the Planning and Zoning Commission to go up to, for short periods of time, up to 98 beds and up to 112 beds for Parkview at one time for a short period of time because DOC did need some increased capacity at those facilities. And the AM included in your packet, the rationale for the ordinance overall does go into that further of correctional needs in the community as well. To let you know, you should also have received support for this ordinance from the Downtown Partnership as well as the Downtown Community Council, the two primary entities affected by this ordinance. Thank you.
Further questions, Ms. Pease?
Yes, if I could, on a general note, how does the increase in concentration, does this, it appears to me that the whole idea was, or what we have an adopted policy not to increase this type of facility in the downtown area. And by adding more beds, even though we're not adding more buildings, are we not increasing the concentration of this type of resident in the downtown area?
Through the chair, Ms. Pease, from my previous experience in reading the history over the years, especially back through and the minutes as well, from the Assembly even, with the early on ordinances, it also included at the time the mile separation between facilities. So it was a very strict reaction, or there was a reaction, I should say, in the community, and a very strict ordinance created for not only density of the number of facilities, but the intensity of the use on the site. Since that time, with the work with the community councils, they'd originally were part of the organizations that were most affected by this and concerned. It had been determined that the number of residents in the building is not the issue as much as it is the location, as you had stated, spreading them throughout the community, but also the footprint, the size of the facility, the land use impacts of the facility, because the individuals are not going to be leaving it's not a day program coming in and out of the building type of thing, so there's not, the parking impacts are still going to be regulated, the buildings are not going to be any bigger, and also it is still not allowing any more facilities within that area. So that restriction has not changed. So in a way, yes, there is, but the buildings cannot increase in size. There will be no visible exterior changes unless it's just an upgrade to the facade. So it won't be a visible increase in density of individuals in these facilities in downtown.
No, but you mentioned the word intensity, so there will be more people coming and going, yes?
If there is, it would be due to staffing. And if there were increased number of staff, right now they're pretty much, from my review, have the parking that they need for the maximum staffing. I haven't gone through all the latest ones. I have not read each of the individual conditional uses. But in working with the Assembly Council on this ordinance and how this would impact land use regulations is the determination had been they would all need to amend their conditional use and apply to you to have more parking and to do more changes to any of the types of buildings. That was a concern by the Assembly member that brought this forward. That is still a concern of the community. So there's a restriction that was put in there on page 28 of the ordinance. That's the S version where it moved from Section 5 to Section 21. At the very bottom, it would be lines 44, 45, and 46. It says the number of beds. This is still referring to the three that in the downtown that exist. That no additional beds in a CCRC established prior to 1995 with internal building area greater than 30,000 square feet. They could only increase, it's saying that they can only increase the number of people in the building if and only if the maximum space ratios permitted are met without enlarging the outer dimensions of the center. So if they needed additional staffing on top of things, they'd have to provide additional parking. In the B2 districts, parking is not required on site, but parking is provided on site on these facilities. If they had to do something else to add additional parking somewhere else, or if they wanted to expand part of their facility, move their kitchen facilities somewhere else, have an outdoor recreation facility on a couple lots down, that would be a modification to their conditional use. If they just wanted to have visitor parking somewhere else, that'd be one thing. So it's a little bit of an odd thing. It's taking program-related things such as the number of beds out of Title 21, putting it in Title 16, but it's not taking those things that are affected by these uses, the characteristics of use such as parking and building dimensions and how those things can impact the community, the coming and going inside the building, coming out, the impacts of the interior of the building on the outside, if you will. And any additional security enhancements that may have to occur, things like that. These are primarily halfway houses, not all CCRCs are. But any of those types of things still would have to come in for modification. This ordinance is not allowing any outer dimensional changes.
One more follow-up, if I may.
Okay, one more.
Okay. This is what I guess I don't understand. I was trying to
Okay.
find out whether this would increase the coming and going of the people living there.
No.
And some of these are habilitative, so I assume they're not under obligation, they're not under restraint. But maybe I'm wrong. So is this an effect on the community? Will there be more people coming and going because there are more people residing there?
Through the chairman's piece, my apologies, I'm glad that you cleared that up. There will be additional people being brought into these facilities. They will be taken in and out or going in and out for whatever needs to the corridor or any other type of rehabilitation or whatever they need. They will not, on their own, be coming and going at will as with some habilitated or some CCRC facilities. These are releasees. It's a halfway house.
Okay, thank you.
Okay, Mr. Phelps.
Yeah, I just need to have some clarification of the amendments to they're identified on the Assembly memorandum. My recollection is that you said that the principal change in this particular ordinance is to the capacity of 30 beds. Is that correct? Did I hear that correctly?
The section on Title 21, correct.
Well, specifically, I guess here's the question. Is there a cap now of 30 beds? It seems like there might be inside the B3 district, but I'm not certain about that.
Through the chair, Mr. Phelps, you're correct. This particular ordinance doesn't address CCRCs in general. Its primary intent is to deal with Title 16 licensing for these types of facilities, but as it relates to Title 21, they brought that part in. Other issues such as occupancy in the B3, there is an occupancy maximum capacity on these in the B3 that was established through the last ordinance, which reduced the waiver. That wasn't brought in because it's not related to these types of facilities. Apparently, that hasn't been an issue or hasn't been brought up to be an issue to the planning department. What was brought up to be an issue to the planning department when this ordinance was being written regarding this is the restriction on the capacity of the downtown facilities. Therefore, because of the reason you just brought up, I still see, as I said, no reason that on a case-by-case basis the commission couldn't decide, and it was a land use impact in a certain CCRC to restrict occupancy for whatever reason. The B3 was not brought into this because it didn't seem to be related to the Title 16 changes, which were of import for this ordinance.
So the real thrust of this is moving some aspects of the licensing and the associated permitting from Title 21 to Title 16.
Correct.
So that's in your opinion, is that, well, it's a substantive change, but are you changing anything of a distinctly substantive nature as a result of that process change?
Through the chair, not in Title 21, with the community being supportive of it. Some of you may remember it was a very large issue when this ordinance came about, originally a very big issue. At this time, it appears to be the appropriate parts of the code appear to be being proposed to be moved to the appropriate areas. I don't see any, myself professionally, any other substantive items being changed at this time. Whether or not they need to be changed, they were not proposed.
Thank you.
Let the record show that Mr. Wilson arrived. Mr. Wilson, do you have anything to declare this evening? Okay, thank you. Okay, Mr. Pruse.
I just have a couple quick catch-up. I'm not quite sure what the, I see on page 4, it refers to temporary increase for the two facilities, from 75 to 98 and 80 to 112 beds.
Correct.
And you mentioned the word short period of time, and I was just wondering, my first question, is there any definition of what that really means?
Through the chair, yes, and throughout the years, I have the history of these in a large file in my office. Health Department also has a lot of their information on this as well. The ones that are non-asterisk is their land use approved occupancy, that they can be enforced that they're conditional use. They have each applied for minor amendments over the years to increase their capacity for short periods of time, because longer periods of time would not have likely have been approved.
Well, how many days is a short period of time?
They varied. They varied. Some were 6 months, some were a year, some were shorter than that. They varied, and Department of Corrections had different information. However, from an enforcement perspective, the conditional use is what governs the land use of that property, and they were clearly tied to those numbers, and they are right now. And if any of these facilities wanted to add 1 or 2 more beds, they would have to come back to the commission to get that done. That's nothing administrative.
Well, how do you enforce? I'm still trying to grasp what this from a capacity standpoint. Where 1 year is a short period of time, or 6 months is a short period of time, which that's completely. I don't think in those terms, but they made a point to asterisk the temporary increase of the beds, but I don't see any where it relates to the percentage of 1 year's occupancy towards that number. And then, which leads up to my next question, is that obviously, what's the staffing increase in proportion to the bed increase?
Through the chair, I did not include any of the amendments for the bed increases, the temporary bed increases. Short-term versus long-term, of course, is relative. The staffing, I am not an expert in corrections or correctional facility management. There may be people in the audience to testify who could respond to that. Mr. Barrett from the Health Department is with Health Department. He is part of the entity that deals with this and could possibly respond to that. That is what we're proposing Title 16 handles, because the occupancy and how the program is managed and staffed is a part of a program issue, and he's available if you would like him to answer that.
So maybe just simpler, how do they enforce the temporary?
Oh, how do we enforce the temporary?
Yeah, what rationale or what test do they use or do they, or can they?
Yes, through the chair, what it was specifically, I can tell you on a couple of them that I do remember off the top of my head that I had looked at. It was an increase to 98 beds for 6 months to start on date X and end on date Z. Now, that did not mean we went and inspected on each day or had land use enforcement go out there and do it, but that's what their extensions were. That's what their occupancy extension, increased extensions were allowed for. It was for those time periods because of their particular needs. It's like with a conditional use for gravel extraction, for example, that wants temporary hour increases. They come and apply for that. If it's granted, they can do it for that shorter period of time. We don't necessarily go out and enforce it. At that last day, go out and double check. But that's how they had done it at that time, because these particular conditional uses were very clear.
So there is no definition of temporary?
There's no definition of temporary. It's a relative term, and so what usually happens with any type of entitlement that's under the purview of a board or commission is that the commission or board sets a time frame that they feel is appropriate, sets a number that they feel is appropriate.
Number of days?
A number of days, a number of occupants for a number of days. Normally, what we're proposing in this ordinance, what the municipality is proposing is the majority of that be handled through the appropriate licensing agencies that deal with the health and the safety issues for the people within the facility, because they have the...
Well, I guess I just find it odd that there's a specific number
Yes.
of beds, but there's no definitive time frame associated with it. And that strikes me.
With the conditional use, these were set with a conditional use because they were set that way. Mr. Barrett will speak in a moment to the Health Department with their licensing. It's been one of the problems for many years for a lot of individuals when they're applying for any type of conditional use to have their residency set by a land use code. They want to, we have so many parking spaces required, things like that. They want to provide for that, have the right size building, and have all that approved. But they don't necessarily want land use regulations to govern the number of people that can be in that building because it's not necessarily, it's more of a health-related issue to them. But the Commission has been setting on virtually every CCRC, rehabilitative care, assisted living facility, nursing home, et cetera, capacities over the years. Not all of them, most of them.
All right, well, I'm not any more clear than what I asked.
It doesn't have to be done that way. It has been done that way is the short answer. It does not have to be done that way. It can be done purely through licensing.
Any further questions for Ms. Chambers? Okay, Ms. Chambers, I have a couple of questions. Number one, is this serving as the public hearing for Title 16 also, or is that going to be done in front of the Assembly?
Through the Chair, that'll be in front of the Assembly. Mr.
Okay.
Barrett can speak to the Health Commission.
You've answered my question. Okay, next question on the same thing that Mr. Pruz was trying to drilling you on. When you say that they're authorized 75 beds, but they can go to 98 beds, is that sort of a permanent situation where they can exceed the 75 beds, but normally they are at 75, and the only time they go to 98 is, for example, when the Department of Corrections says we got a bunch of people we're releasing and they need to go to a halfway house type thing?
Through the Chair, no. That was just for one. That was for one instance. They were allowed to go to that. Parkview, for one instance or two instances, I can't remember, was allowed to go to 112 for 2 short periods of time or 1 short period of time.
Okay.
Cordova applied several times to change theirs and was not allowed.
Okay. And so once they've gone through this period where they're allowed to have more people, then it dies, and you go back to 75. So each time they want to exceed, you have to go in for an exception.
Correct.
Okay. So all this is telling us at one time there was 98 at Glenwood and 112 at Parkview.
Yeah, correct. Due to the density and intensity issues.
Okay. So it's not a permanent thing. It just, at one point in time, they asked for more people and it was granted. Okay. All right. Okay, Ms. Pease.
Yes, through the Chair to Ms. Chambers, when we get around to making findings, does staff agree with and affirm Assemblyman Flynn's comment that the halfway houses have operated in Anchorage for 20 years or approximately 20 years, and that they have operated without significant incident caused by residents? Do you know anything about the record of performance?
Through the Chair, I have no record of complaints, land use complaints.
Okay, thank you. And then there was a comment in our packet about separation from licensed daycare centers, and I didn't see whether that, it wasn't from a staff, it was from a community council.
Through the Chair, Ms. Pease, Ocean View, I believe.
Yes.
Other things have been brought up as well because of it. A lot of it has to do with also the Title 21 rewrite. There's other things people were wondering if they could see in this ordinance. This is an ordinance not being proposed as part of the Title 21 rewrite. So some of those things did not get amended in here. This is the Title 21 part was just brought in to assist with Title 16.
Okay, thank you.
Okay, Ms. Chambers, you do have somebody here from DHHS?
Yes.
Do you wish to speak and add some information?
I do. I was trying to turn on the microphone over here, and the other one was not responding. I'm Tony Barrett with the Department of Health and Social Services, and I manage the food safety program. And there are a couple questions that I may be able to address through the Chair. I think the temporary increases that are laid out in Table 4 had dates certain in the conditional use permit that granted those. So your question about what does temporary mean, I think, was defined in the ordinance that allowed that temporary increase. So So I believe that answers your question. There was a specific date set in the ordinance under which, or past which, or beyond which that increase would not be approved. The Health Department may have issued operating permits to those facilities, however, based on those higher numbers. So I need to do a little bit of research there to find out if we have somehow incorporated what was intended to be a temporary increase into the permits that we have issued for those facilities. And I don't know the answer to that. This is new to our program. The folks who used to work with the department doing this kind of permitting have left long ago. We haven't issued a new permit for over a decade. So trying to kind of dust off the cobwebs and figure out how to deal with facilities is not easy. And then when someone like me comes in who has no history whatsoever, it makes it a little tougher.
Anything else, Mr. Barrett?
No, I'd be happy to answer any other questions about how this relates to Title 16 or what we're doing with that, but I think I'll stand down now.
Okay, well, we'll go ahead and open up the public hearing now. Let me read the rules. After the staff presentation is completed on public hearing items, the chair will ask for public testimony on the issue. Persons who wish to testify will follow the time limits established in the Commission Rules of Procedure. And these time limits are petitioners, including his or her representative, 10 minutes, and part of this time may be reserved for rebuttal. In this case, it was the municipality. Representative groups, such as community councils or PTAs, have 5 minutes, and individuals have 3 minutes. When your testimony is complete, you may be asked questions by the Commission. You may only testify once on any issue unless questioned by the Commission. An individual may have appeal rights relating to any action the Planning and Zoning Commission takes. Appeals must be filed with the clerk's office within 20 days after the Planning and Zoning Commission's final decision. And finally, any individuals may request written findings from any Commission decision within 7 days. So the public hearing is now open. Is there anybody that wishes to testify? Please come forward and state your name for the record.
Good evening. My name is Ron Alleva, spelled A-L-L-E-V-A.
And what do you represent, sir?
Pardon me?
Who do you represent?
Myself.
Well, yourself. Okay, you got 3 minutes then.
Okay. When does that start? Go ahead, hit the light.
Whenever you're ready.
I'm ready. Hey, and I'll talk fast. I'm an auctioneer, so listen attentively. At the council, when I listened to this proposal, I live nearby. My auction yard, etc., and I hire residents from this facility. What they wanted to do, or explained to us what they wanted to do, was to take out the kitchen and put in an extra bed. These are called halfway houses. You're acclimating prisoners from a prison situation back into a semi-housing situation, which includes a kitchen. Why would you eliminate that, put in a bed, and then feed them like in a dormitory situation? That to me is no more than a prison bunkhouse. I don't want to see that done. And I think what you're missing here is connecting the dots of the overflow burden of having additional residents, clients, criminals doing their time at a halfway house. Because it's always an expansion of these facilities. You just can't get away from it. Recently, I objected to Carlick Manor. You gave them Carlick Manor on a conditional use. Now they have the clinic for chronic inebriates opening up at 4th and Juneau. One leads to another, leads to another, leads to another. Before you know it, it's out of hand, and you've destroyed the neighborhood, because you can't go backwards. And the people who strongly objected to this, to keep it confined and limited, they're gone, including Bill Weimer, who may end up in prison in Florida. So we already have the jail. We have an issue with the jail because they drop off all the criminals there. We have Sleep Off. We have Beans. We have the Brother Francis Shelter, who was given a conditional use for the maximum of 240 people with the goal of 180. But yet at Christmas time, the population was 381, out begging for more money. And when they kick those people out of the shelter, where do they go? To the neighborhood. These people transition through the neighborhood, and they're not being watched. If you call for a cop in Fairview, and I'm in my work clothes, you better show them your hands. That's where we're at in calling the police in Fairview, because you're always a suspect. You're never a citizen calling in something. Hey, show them your hands when you approach the car. That's the fear we live in. We have the methadone clinic. We have Henry House, people on drugs. I think that poor gentleman was out of Minnesota, sliced that man's throat, I think it was 9 times. In conclusion, I'd be real cautious to let this get out of hand and replace those kitchens with beds. Do you have any questions?
Is there any questions for Mr. Oliva? Ms. Dean?
I just had one question. Do you know how many of the residents are walking away from those particular houses? Do you have any experience with that?
You mean from the halfway houses?
Yeah, I mean just walking away. I've heard there's a problem with that they just walk away and they jump out a window, whatever, and they just take off.
Well, that would be a statistic I think is documented, and that's when they're supposed to return by 5 o'clock. Because I hire them, they get to 5:30 to get there. If they're not there by 8 o'clock, then I think a bench warrant's issued, and then they're in violation of their parole.
So you pick them up and then you take them back at the end of the day, or do they just walk over?
They walk, and you really got to track them, and, you know, they're allowed bicycles, but the bus route. And many of the jobs, not only that I provide, but they're way out on King Street. And these guys are, you know, basically going through the neighborhood. And I know they want to offer to pick up garbage, and they do good things, but hey, they're also casing the neighborhood. As they walk through picking up garbage, they're viewing, hey, here's a car, here's some equipment, here's a bicycle, this is my route to get out of town. So it's not entirely safe. And you keep putting more pressure on that neighborhood, it's going to either collapse or explode. And it's going to be done by this commission.
Mr. Cruz?
Thank you. Could you tell me what the total impact as far as folks at the maximum levels of all the different facilities in the Fairview area? Just how many, if you added everything up, all the different halfway houses, drug houses? What are we talking about?
I would say it exceeds thousands. It's in the past 1,000, maybe 2, even higher.
Is there any other community in Anchorage with anything close to that?
None whatsoever. And they continue to saturate, and the more you anchor facilities there, like the clinic that came in to service the chronic inebriates, they didn't need any permits. They didn't need anything. And they're on 4th and Juno. I mean, there's no crosswalks there. None. I mean, there's no crosswalks from Reeve all the way to Cordova. There's only a flashing light. And believe me, I've lived down there for 28 years. My business is there. I know every path and every basic light there, and it's not a safe area. This is not a good thing for downtown. This is not a good thing for Fairview. Limit it. Keep the kitchen. Do away with the beds.
Any further questions for Mr. Oliva? Thank you, sir. Is there anybody else that wishes to testify?
Hi, my name is Trey Watson. It's Trey.
And you're representing, sir?
Cornell Corrections of Alaska.
Okay, you've got 5 minutes.
Right. Thank you. As I said, my name is Trey Watson, and I'm here on behalf of Cornell Corrections of Alaska. I'm the Senior Director for Cornell Corrections of Alaska, and I currently oversight the 3 centers in Anchorage, the 3 Cornell centers in Anchorage. I'm here in support to support the adoption of AO 2011-1, containing proposed changes to Title 21 as well as Title 16. I'd like to take a moment to explain the role and the function of the CCRCs in Anchorage. They operate currently under contract from the Alaska Department of Corrections to house primarily two types of offenders: residents who are transitioning from a longer-term sentence from prison back to society, and residents who are either serving a shorter-term misdemeanor charge or are awaiting trial. The majority of residents are required to perform a minimum of 40 hours of community work service at various nonprofit and government agencies all over Anchorage. Excuse me. As well, the CCRCs provide eligible residents the opportunity to engage in programmatic as well as therapeutic services, which include job servicing and working in the community, not available to them in jail and certainly not on the streets. The CCRCs also provide an increased level of safety and security to the public and to the residents of the center. We believe the proposed changes in AO 2011-1 to Title 16 and 21 are beneficial to the Anchorage area. Firstly, that the proposed changes help to achieve the Anchorage 2020 Comprehensive Plan, removing the restriction on the number of occupants at large facilities, such as Cordova Center, that have been around since 1995, from the current ordinances will allow the State of Alaska DOC and the Federal Bureau of Prisons Community Corrections Division to place more offenders in a structured, supervised, and safe environment. By doing so, we can further achieve the goals of the 2020 plan by expanding the availability of transitional and special needs housing in the downtown area at the current location. This allows other space to remain available for other uses identified as appropriate for the downtown district. Secondly, the proposed changes will also increase public safety. Placement in the CCRC can lead to a reduction of homelessness and recidivism by providing the offender tools and skills necessary for successful integration into society. When beds are not available in these in halfway houses, offenders are likely to be released without support or much or little supervision. Third and lastly, the benefit to the city is an improved regulatory authority for the DHHS. This will allow them to more efficiently regulate and inspect the existing CCRCs. As well, it will update and make the MOA's licensing more similar to current national standards such as the American Correctional Association, the Department of Corrections standards, and the Federal Bureau of Prison Correctional standards. And that's all I have. I'd be happy to entertain any questions.
Okay, Mr. Watson, I want to apologize because I should have only given you 3 minutes, and you finished within your 3 minutes, so you're okay.
I practiced it for 3 minutes, so thank you.
Okay, are there any questions for Mr. Watson? Okay, fine, thank you, sir.
Could I add one more thing? Is that possible?
Not unless you're questioned.
Okay, thanks.
Okay, okay, Ms. Yoshimura.
My question is, what is it else that you would like to say?
I failed to mention that we did present this in front of the Fairview Community Council as well. The issues that the prior gentleman mentioned were brought up in that meeting, and they still decided to support our projected plan.
So, just so that I understand correctly, you are already operating at the higher capacity, is that correct?
Correct.
So by sort of legitimizing the higher capacity, we're not adding more, or are we?
You would give us the ability to add more beds dependent upon customer needs, such as the Alaska Department of Corrections and the Federal Bureau of Prisons Community Corrections Division.
And that would be by reducing the size of the area to, instead of 10 by 15 to 10 by 10 with a community dining facility. Is that how I understand?
Well, the actual living space would be increased by taking out the residential apartment-style kitchens.
Right.
We would install either an institutional-style kitchen, but we would have the residents actually participate in the meal prepping, serving, cooking. So the benefit would only be lessened. They would still be engaged in preparing meals and learning those skills as well.
So do you have any statistical information that would substantiate that this is a better living plan than the individual efficiency kitchens?
I don't know that I would say a better living plan, but nothing is lessened. So, for example, I can say that all our other facilities in the outlying areas of Bethel, Nome, and Fairbanks operate in that capacity. And we have, as far as I can tell anyway, with statistics, the same success rate at those facilities. They operate in more of a dormitory style eating arrangement, as well as all of our facilities in the lower 48 operate in that manner as well.
Did you inherit this style in the acquisition of the buildings? Is that?
Correct. Correct.
So when you acquired the buildings, they were already these efficiency-style residential apartments?
As far as I know, I came on in 2003, but they were that way then, and as far as I know, prior to that, they were. In other words, they have always existed in that capacity. Yes, ma'am.
Okay, Ms. Pease?
Yes, through the chair. Do you have any information about the success rate in terms of residents who serve out their time in the halfway facility versus residents that have to be returned to more strict correction facilities?
Certainly, mostly I can speak from personal experience, having done this for about 8 years now. At least for the program residents, I can tell you that I have, it's rare to see somebody who's successfully gone through the entire program to come back to our facility. Now, I don't have exact specifics on if they got rearrested or if they reoffended once they were on probation, but I can say for being at 2 different centers for a number of years, the program residents, the ones that went through treatment and the ones that got jobs and were giving assistance to get living arrangements outside the facility, rarely come back to the center in that capacity anyway.
Thank you.
Ms. Chambers?
Through the chair, page 7 of your staff report, I forgot to mention because I don't have the document with me for you, was that Member Flynn noted on the last page of the AM that the Fairview Community Council as well had endorsed the proposal. I do not have that document, just the other 2. Thank you.
Okay, Mr. Bruce?
Thank you. Based on your time working this issue and this increase in capacity, how soon before this capacity you'll have to come with another growth problem? I mean, based on the current, I guess, growth rate of the bed capacity that you need, how long is this going to last, and then how long before this actually is maxed out and you have to do something different, based on the current statistics?
Sure. That's, quite frankly, probably better answered by the Department of Corrections or the Bureau of Prisons, but I can say that if this is successful, this would probably be the last time we would come to need this, because we would essentially be maxing out the capacity of the building for safety reasons and things like that. But I don't...
So you would need another facility?
Most likely, yes. And then perhaps in a different location and not necessarily in Anchorage, depending on the need of the state and different requirements. So.
And what is there a predetermined prerequisite that they stay in Anchorage versus going someplace else? Is it where they live? Where their home residency originally was? What precludes? Why does one go to Anchorage?
Sure.
Versus
and with some latitude, I'm probably speaking on behalf of the Department of Corrections, but it's mostly based on geographic location. If you're arrested in the Anchorage area or even the Valley, and you are eligible to go to the CRC in Anchorage, then that's where you would go. If you get arrested anywhere else in the state, it's going to depend on the district that you're arrested in, the geographic location that you claim residency in, depending on which center you're going to go to. So,
are there any of these in the Valley?
There are not that I'm aware of. None with our company, and I don't think there are any classified as a community correctional center. There may be some transitional housing. I don't know if other agencies have some there or not, but not that I'm aware of.
Any further questions for Mr. Watson? Thank you, sir.
Thank you.
Anybody else wish to testify? Anybody else wish to testify? Okay, I'm going to close the public hearing. Ms. Chambers, do you have anything, or DHHS, anything you wish to add?
No, Mr. Chair.
Okay, Ms. Pease.
Yes, through the chair. To follow up on my earlier question, Ms. Chambers, we did hear from the member of the public, Mr. Oliva, who testified that people do go AWOL on these programs, that they walk or bike or take the bus to or from work. So going back to my original question, is there not then an increased intensity of the presence of the residents, at least going in through the neighborhoods?
I would, through the chair, yes, there could be. The more people you would have in a facility, if people are leaving the facility with permission, then yes, there's an increased amount of people through the area or without permission either way. Same with the residential density as well. It's just a totally different type of use as the individual attested to in a
Okay. And the reason I ask is I'm not sure that as the Planning and Zoning Commission, we have that much of a role on the intensity within the building on how much kitchen space is needed or how much bed space is needed. But we do, I think, have a role on the intensity of use from this type of facility in the neighborhood. So that's why I'm not familiar with how it works. But it sounds to me as if these residents do come and go on their own without escort or direct supervision, and they make their way to possibly all points of the bowl, but they come back here, so they're concentrated here.
Through the chair, that's correct. In Ms. Pease, as was stated earlier by the individual who testified, and also, as I has also stated earlier, it is completely not uncommon for any type of entitlement coming through the commission for any facility, even a planned unit development, to set a certain density, a zoning district to set a density, for use to set a density. The only thing, the thing in here, if there's a concern on that issue, is on page 29, just to work from the S version, is the commission frequently sets a cap, if you will, and it doesn't prohibit a petitioner from coming back and applying to change that if they've met whatever concerns the commission, or if they feel they've met the concerns of the commission. Section A just refers to the 3 downtown. It just removes that ban from applying to amend that program cap. That C and D basically says that it's changing it to state that currently it says program occupancy limits shall be as determined by the State Department of Corrections. It added the wording to say by Title 16 as well. And D, it took out the wordings that the land use standard to establish maximum resident occupancy. If there are concerns that the commission has on that, then the clarification would be in those two areas. I still don't see that the commission would be prohibited by this from saying, if you want this conditional use, say a new facility or another facility coming in, or somebody coming in to amend their current occupancy limitations so their conditional use from the, I don't see anything prohibiting the commission from instituting a maximum capacity.
Any further questions for staff? Okay, Mr. Bruce.
Yeah, just one question. Do you happen to have a map, or is there such a thing, of all the different locations in the Anchorage Bowl area of these facilities and the halfway houses, and where they're actually physically located?
Through the chair, not with me here, we have, when we last looked at this ordinance with the mile radius issue versus reducing it, the separation between the uses, reducing it down to 1250, we had a map at the time of the different ones in the Anchorage Bowl area. There are not that many CCRCs. There's more rehabilitative care facilities and other types of facilities. There's a kind of a fine line between many different types of rehabilitation and transitional living type of facilities, from a halfway house all the way down to a regular, a single-family house with people that are living in it, recovering from different things. So we don't have a map with all of those put on it tonight. I can tell you that was part of, for the testimony earlier, there is, and the reason for this ordinance in the density and intensity issues in the downtown Fairview area is because you do have a lot of different types of related uses in those areas. There is I believe I've heard that before with other facilities that have come in within certain areas of town. There are definitely a significant number of related between homelessness, CCRC, and other types of facilities in those areas.
So I could get one eventually from you that you have? That you did?
Yes, so CCRC wouldn't be very difficult to put together at all. It's the many different ranges of those types of housing, special supportive types of housing. It would take longer to do. We can get one for you and work it out for you, certainly. A time frame I can't give you, but relatively as soon as possible.
Thank you.
Through the chair, Mr. Bruce, this is Tony Barrett, DHS. I just wanted some clarification. We have a list of, there are only 4 CCRCs that are licensed, so I mean, it wouldn't be that difficult to put together a map indicating those. As Ms. Chambers was indicating, there are other, what are now called quasi-institutional facilities as we permit them, or habilitation facilities, but the total number that the Health Department has permitted is only 14. So it's not that difficult to identify them on a map or give you a table or a list indicating where they are.
Yeah, a map with all the different permits that you've given out would be great for help.
Yeah, generating a map takes just a little bit longer because we have to locate them on there, but it's not that difficult. I would think certainly by the end of the week we should be able to put together such a map for you if you'd like to see that.
Any further questions for Ms. Chambers? Ms. Chambers, I have one question, just to get things clear in my mind. As I understand it, the only thing we're dealing tonight with, and that are seeking approval, is page 28 and 29 of the S version, and that's 2150-035, and everything else is Chapter 16.
That is correct.
Okay, so we're only dealing with 2 pages of stuff. Okay.
That is correct. And through the chair as well, just to brief follow-up from what Mr. Barrett said, he and I are working together a lot on these types of issues. And we're getting together other lists and making sure our information jives together, so we'll make sure you have that. It's helpful for...
Fine. Ms. Yoshimura.
Well, on page 32, I have a question regarding 16.80.140, because it looks like the proposed amendments would eliminate the requirement for a public hearing, which is what we're doing tonight, held by DHHS or held by the Planning and Zoning Commission as part of the original review and approved for permitting, and would also remove the requirement for a hearing when a permitted facility is sold or ownership is transferred. If for some reason the public hearing called for in 16.80.140 is not eliminated, DHHS would like to see .170 amended to eliminate the requirement that these be treated as new permits and the requirement for a public hearing. Well, when we're talking about a public hearing, are we talking about a public hearing here at the Planning and Zoning Commission or DHHS?
Through the chair, that's for Health and Human Services. They still, all of these require conditional use, all require a hearing. Through you, that is for their licensing. Mr. Barrow will speak to that.
Through the chair, Ms. Yoshimura, that what we're asking for in our S version that goes before the Assembly tomorrow night is that they remove the requirement for a second public hearing to be held by the Health Department after the public hearing on land use issues that's held by the Planning and Zoning Commission. What we're saying is that a second public hearing for an application for a new permit held by the Health Department really adds nothing beyond the hearing that you folks have. And so we're asking that be eliminated. The latter part of my memo, what I was saying is that under our current ordinance, if a facility changes ownership or changes hands or changes management, the way the ordinance is written, they're treated as a new facility and they have to have a public hearing. And at that public hearing, if people come in and think that this is not a good facility to be in the community or not a good location, it puts the Health Department in the position of having to determine whether they want to continue to issue an operating permit to an existing facility that just simply is changing ownership. And I think that's a bit disingenuous. I think that it's unlikely the Health Department would decide to revoke or reject an applicant who has purchased a facility that's been operating for a long time in a community. So that's the reason for suggesting that hearing be taken out of the Public Health Department's hearing requirements. It still leaves intact a hearing that's held before this body when a facility wishes to be placed in a community or wants to expand in a community. You still have those hearings.
Sorry, what process, sir, do you go through for the DHHS public hearings?
Well, I can only speak to the process as is laid out in the ordinance. We haven't had one for over a decade, and there isn't anybody on staff who's been blessed with the privilege of conducting one of those hearings. But it would be very similar to yours. I mean, the staff would do a report on what is being proposed. We'd take public testimony. We'd hear from the residents and from the applicant. And so essentially what has happened with those hearings in the past is it's another opportunity for the community to come in and talk about whether they want the facility in the community. That decision has already been made by planning and zoning. So the health department feels that the things that we're supposed to be responsible for, the operational issues, are not addressed at those public hearings. And so the public hearings don't add any value to the process that we're responsible for. And they give the public the sense that there's another opportunity to weigh in on the land use question, which has been decided by this group, not by the health department.
So they're publicly noticed and published in the newspaper and are posted on the facility or on the lot, or how does that work?
Oh, yes, ma'am. There are requirements in the ordinance now, as it stands now, for public notice to be provided to residents within a certain distance, and I'm not sure what that is. I'd have to it's in the language of the S version that's being stricken. I just don't know it well enough to know what those requirements are. But the ordinance does address what we're supposed to do in terms of notifying the public, notifying residents, much like planning does for hearings that come before you. It's a very similar process.
So has there been no transfer of ownership, or has it just been an oversight by DHHS that you haven't had these public hearings?
Through the chair, Ms. Yoshimura, my understanding is that there have been some transfers of ownership of facilities. However, the health department has determined that there was no reason to have a public hearing to determine whether on those transfers of ownership. So they've been treated without having public hearings. And the health department has reviewed the operation plans, the staffing plans, the house rules, those sorts of things for the new operators, but have not required a public hearing. That's my understanding. Again, I've not been here long enough to see that actually play out, but that's what I believe has happened.
So have I missed something here, or are you not required by ordinance to do that?
No, through the chair, Ms. Yoshimura, I don't think you missed anything. We are required by ordinance to do that. My understanding is that's not been the practice, and so part of what we're asking before the assembly tomorrow in the change of the S version is to reflect the practice that has been done for the last 10 years. But you're absolutely correct. There's nothing in the ordinance that says the health department can waive that public hearing.
I'm sort of a stickler for process.
Okay, Ms. Chambers.
Through the chair, just to comment on the notification procedures, page 24 of the ordinance of the S version. Page 24 of the packet is page 9, section 1680-140A in the capitalized print. It's mailing within 300-foot periphery. Published in a newspaper of general circulation.
Okay, thank you, Ms. Chambers. Okay, we need to get a motion on the table here so we can move out on this thing. Been moved by Ms. Pease, second by Mr. Frederick. Ms. Pease, would you please make your motion?
In the matter of 2011-017, I move for approval.
Okay, do you want to speak to your motion, please?
Yes. We've heard in the past a great deal of controversy and community input on institutional facilities that serve residents in the correctional system. One of the kind of remarkable facts about tonight's issue is that there hasn't been any public, there's been one person testifying, and the community councils in this area, downtown and particularly Fairview, that tend to be very active in this sort of issue, have apparently had presentations on this expanded number of residents, and according to a letter by Assemblyman Flynn, they have approved this. Now, I did not find this letter in the packet, but we'll look to a nod from staff to see if they understand that those two councils are in approval, and I do see that confirmation from staff. This does appear to be consistent with Policy 61 of the comp plan, promote the availability of supportive housing opportunities for the homeless and for persons with special needs. It's less clear how perfectly this is consistent with Policy 62, which requires us to try to distribute throughout the municipality residential facilities that are supported by government agencies and operated for health, social service, or correctional purposes. It appears that this does not add to the clustering of facilities, but it does add to the clustering of residents in halfway houses in the downtown area. But it also, we've heard in testimony that this level of intensity has already occurred as temporary increases. And I guess we can infer that the downtown and Fairview councils have felt this intensity is tolerable because they have not objected to allowing these permanent increases within the existing buildings. So we're not endorsing an expansion of the buildings, but apparently an expansion of the services to additional residents within the buildings does not appear to be a problem for the neighborhoods. And I'm not sure that it is necessarily a planning and zoning area of authority to decide how much kitchen space or living space is appropriate. I think that appears to be properly the purview of Health and Social Services and other agencies that look at how to serve residents or inmates of these types of facilities. So I will be supporting this issue, and if anyone wants to speak to the public process, I'll be open to any friendly amendments on that issue.
Anybody else have any comments? I think Ms. Yoshimura.
I do.
Okay, go ahead.
Well, I'm not sure exactly how to put this as far as where the amendment should go, but because it is, I am sympathetic to everything Ms. Pease says, but I am also believing that DHHS should continue or start to implement the process that has been required over the past 10 years by ordinance, because this is an area of concern, the potential clustering for all, for a variety of social support services in this neighborhood. And even though tonight we have not heard from the community councils and they are supportive of it, I am aware of all of the prior arguments that have gone around regarding Carlick Manor, and as important as these facilities are, I do think they deserve the additional public process. So I would like to make a friendly amendment to Ms. Pease's motion that the proposed amendments to eliminate the requirements for a public hearing held by DHHS and this whole paragraph not be included in our approval process. I believe that it is worthy of a second public hearing for the public to weigh in.
Okay, Ms. Chambers, okay, I think we got a point of order here, but Ms. Chambers, you can start out.
I'm not sure quite if this is a point of order or point of clarification of both. The Commission's actions just tonight is only on Section 21 of the S version, Section 5 of the other version. It's the same thing. On 21.50.035, Ms. Yoshimura, were you speaking to the part of Title 16 on the...
Right.
Okay.
No authority over that?
No. And my suggestion, no. However, any concerns that any board or member of the public, I'd make the same suggestion. is instead of a motion to the ordinance, since the commission has no authority over it, to make recommendations to the assembly on that title, is instead to include that in your discussion for the findings of fact of any items you may have concerns on or support of or anything else. Granted, this is going to the assembly tomorrow night. However, in the morning, I will advise my supervisor of your concerns.
Thank you.
And I think the point is that we have no authority over Title 16, but we can sure make comments in our findings that somebody needs to look at this tomorrow night. Okay, are there any other comments? Let's see, before we vote, we need to have some findings, Ms. Yoshimura, I think, that deal with what you were discussing there. And Ms. Pease, is that satisfactory for you?
Yes, I made a couple findings, and I invite Ms. Yoshimura to make the
Okay,
findings.
well, let's go ahead and put the findings together before we go ahead and vote, so we know what we're approving. Let's let Ms. Pease start, and then you can add your findings to hers.
Mr. Chairman, I thought I did make two findings regarding policies 61 and 62, and also I noted that the community council has apparently, two community councils have apparently met with the petitioner's representatives and approved this. So does the secretary have those in the record? Okay.
Okay, fine. Okay, now, Ms. Yoshimura, wait a minute, Mr. Pruz, you've got a comment here.
On these letters from the community council, could you tell me, are they just generically support it? Do they support it with any conditions? Do they support it with any future recommendations?
Through the chair, they're generic. Well, I wouldn't say generic, but they were in support of the ordinance is written for the proposal that was given to them. Jim North provided the proposal, I believe, to them. Cannot speak for the assembly or Assembly Member Flynn, who's also had those communications, and other individuals. They're in general supportive of the ordinance. And also, I believe, Ms. Yoshimura's comments were actually findings of fact, I believe, that she had said earlier.
Okay, being new, we don't have a paper in front of us. How do you find?
I have them. I have two. Through the chair, I have two in the file. They were not emailed to you last Tuesday. The two letters from the down. I have the down. All I have is a downtown partnership and the downtown community council letter. I do know, however, from several sources that as well as the AM, that the Fairview Community Council also is in support of it. I can show you the other two letters and read them onto the record if you'd like.
I'm just on process confused on how you find facts or finding without the actual letter as support. Just someone saying something. Is that good? Is that how we do it, or that maybe it's a question for the chair?
Do you physically have the letters here, Ms. Chambers?
Through the chair, I do. They have them here, and they are physically part of the record. They should have.
But we don't have them.
Yes, so I can.
Why don't you read them into the record so we can hear them, and we'll know, and that way we can recognize and say, fine, there are these letters of support, and they really exist, and they're not, vaporware.
Thank you, Mr. Chair. I appreciate it. Downtown Community Council, dated February 8th, 2011, to whom it may concern, the Downtown Community Council passed a resolution on November 4th, 2010, in support of Cordova Center increasing the addition of up to 90 beds without physically expanding the facility. There's an identified need by the Federal Bureau of the Prisons and Alaska Department of Corrections, and so the Cordova Center, privately owned community correctional facility of 130 Cordova Street, Anchorage, Alaska, 99501, currently has a capacity of 192 residents and wishes to add up to 90 beds without physically expanding the facility. The Cordova Center has been a good neighbor and has also donated over 26,000 hours of service to the Anchorage community in the past year. Anchorage Downtown Partnership, approved this day of 28th October 2010. Whereas the Anchorage Downtown Partnership Limited is a 501c6 nonprofit entity charged with management of the Downtown Improvement District, and whereas the mission of the Anchorage Downtown Partnership Limited is to increase cleanliness, occupancy rates, investment values, and lease income, to decrease crime, and to generally stimulate economic development and improve the quality of life in downtown Anchorage. And whereas the GEO Group, Inc. is a leader in the delivery of private correctional and detention management, community reentry services, as well as behavioral and mental health services to governmental agencies around the globe. And whereas the GEO Group, Inc. has a contract with the Alaska Department of Corrections to manage the downtown Cordova Center and 2 other centers used for inmate transition. And whereas the Cordova Center provides temporary housing, monitoring, and transitional services for 192 minimum security inmates. And whereas the Cordova Center offers voluntary programs and services that prepare inmates for their return to society. And whereas the GEO Group, Inc. is well known for creating a safe environment for their inmates and for giving back to the communities in which they are located. And whereas the GEO Group, Inc. and Alaska Department of Corrections would like to increase the number of inmates served at the Cordova Center, and whereas increasing the number of clients served at the Cordova Center will not require any changes to the size or structure of the Cordova Center, nor have any impact on the traffic volumes or parking supply of the surrounding community. Now, therefore, be it resolved, the Anchorage Downtown Partnership Limited supports the request of the GEO Group, Inc. and the Alaska Department of Corrections to increase the number of clients they are allowed to serve at the downtown Cordova Center facility. Mind you, point of clarification, these are letters received regarding this overall process. This is only the ordinance, though. Anybody coming back to do anything with capacity would still have to go through the commission with a conditional use amendment. And that's just my aside at the end there.
Okay, Ms.
Oh, darn. Through the chair, currently all the CCRCs out there that are approved by the Planning and Zoning Commission have a maximum capacity on them set by the commission. Any of those are it's a condition of approval. If they wanted to change that, they'd have to come back to you to have that number changed. Just with this ordinance. You've already set that. So these letters were in support of this process. What this ordinance is read, they read towards Cordova Center and towards increasing their beds. The intent of this ordinance is to allow individual CCRCs to come back to apply to amend their conditional uses to increase capacity. Passing this ordinance tonight would not grant blanket approval for capacities without any type of other action, however. There would still need to be the public process through Title 21.
Okay, Ms. Pease?
Yes, I would like to add to the record of our findings what Ms. Chambers just stated, which is that this does not result in the blanket ability to increase capacity of other CCRCs, but those facility operators would have to come back to the commission for approval, the Planning and Zoning Commission.
Mr. Bruce?
Yeah, I didn't. The first letter was written by who? What group?
Downtown Community Council.
I'm sorry?
Downtown Community Council.
Is Fairview anywhere? Is that Fairview?
Through the chair, no. I referenced that was in the AM in your staff packet prepared for Assemblymember Flynn by the Assembly Council.
So we don't have anything from Fairview?
I do not. That was from the Assembly Council stating that had been received, and I believe there was public testimony to that effect. I do not personally have anything.
Any further comments? Okay, is there any objection? Okay, all right, we're going to need to use our machines. Okay, a yes vote approves per the recommendations on page 3, and again, we're only dealing with the Title 21 portion, which is contained on page 28 and 29, section 2150.035. So please vote. That passes. Okay, only comment I have tonight is on the committees. If anybody wants to add their name to any of those committees, please feel free to contact myself or our glorious secretary who keeps track of this stuff. And,
Mr. Chairman?
yes.
Do we actually have a school site selection committee?
It's still on the books, but we don't.
Yes. It comes up every now and then.
Yeah. Rarely do we have to meet. We're running out of land, so.
Have added the school budget capital improvements
Yes, ma'am.
committee that Mr. Wilson is going to be on, right?
Yes, we have.
Okay. And I guess since we have you here, Ms. Chambers, what's the process for everyone to be noticed about these meetings? How's that going to work since?
For the committees?
Yeah, for the committees, because the Planning and Zoning Commission wishes to be more involved and have attendance at some of these meetings.
Through the chair, a lot of those, if not all of them, are pretty much not within my section. However, I've been working with different section managers, and I know Ms. Wong certainly is highly interested in having you involved as early as possible with the committees that would be involved with her work. School site selection would be a party to that. The school district starts along sometimes before it comes up to us. However, it's staff working with other staff, and they're there to notify you, to get you involved. And when I hear of things coming up, to take action through the director, to get you involved at those times and to get them on your monthly luncheons. There's no official process, in other words.
Just a comment. We did receive something, I believe, about AMATs, where we can actually sign up for getting notifications of AMATs meetings and stuff like that.
Correct. And I would say after the meeting, you should speak with Ms. Graves on that,
Right.
who works with that.
Okay, Ms. Page, you had a question?
Yes, two quick comments. One, to follow up on the case we just heard. I was not comfortable and tried to be very careful in reading my findings into the record that we didn't have the documentation of the Downtown Community Council or Fairview Community Council support in front of us. I'm glad that you had a couple of those documents. If there are such documents, I think it's really important that they be sent to us as part of our packet. It's very uncomfortable to hear, even though you're reliable and Mr. Flynn is reliable, we still need to see those for ourselves. So I hope that, and I also, in attending my community council meeting recently and listening to discussion on the Mountain Air Drive, there were comments apparently from the Anchorage School District that didn't make it into our packets on that issue. So I would like to just make sure that we get in writing all the comments from agencies and communities and individuals, especially, if they come in before the meeting date, that we know about them ahead of time. And then second, with the electronic transmission of the materials to us for this meeting, it worked all right for me because there wasn't a lot of markup required, but in general, when we have thick documents to go through, I much prefer to have the hard copy in front of me to mark it up, and I think there's some validation for that. They've shown that when we're reading something in front of us, it's a different mental process than when we're screening through it, even if, even the younger folks. So for documents that are lengthy and have maps and graphics or that require some markup in the future, I hope we can have the hard copy, not just the electronic copy.
Thank you for verbalizing that, Ms. Pease. Standard operating procedures, that you get a hard copy and electronic copies, and that you also get everything we get up until the moment we leave from our workplace to here, so you at least have them at the hearing. There have been a couple issues of late. My apologies.
Thank you.
Any further comments? Need a motion to adjourn. Okay, moved by Stacy. Terry. Any objection? Okay, we're adjourned.
I'm shocked at the departments that do not follow policy.
This is weird.